Start with AB 20.
Okay, AB 20.
Thank you, Mr. Chair and members. I come before you to urge you to support AB 20 in an effort to address critical agricultural worker shortage facing California by creating a pilot ag worker permit program for workers already residing and working within our state. Again, already residing and working within our state. It would be the first of its kind program in the country. But every year, California's 81,000 farms grow over half the nation's fruits and vegetables. Over 90% of our California farms are family farms or partnerships, but over 60% of those are less than 50 acres or less. So this is not big ag in the traditional sense. It's a generational legacy of family-owned businesses and entrepreneurial enterprises that have had to worry about meeting their payroll, hedging against fluctuations in the commodities market, and worrying about the ongoing drought or if the next wild fluctuation in the weather will destroy the season's crops. Yet despite the vital role of agriculture in California's economy and tax base, the ongoing labor shortage has farmers worrying every year if they should invest limited resources on planting another season of crops when they simply might not have enough labor to harvest it. It is well-known fact that California's agricultural industry is heavily dependent on immigrant labor that is estimated that 50 to 75% are undocumented. Likewise, California's farm workers have contributed mightily to the state's economic foundation, but are confronted with the fear of family separation due to deportation. And meanwhile, party dysfunction has derailed comprehensive immigration reform in Washington, and now California's agricultural industry faces serious labor shortage challenges. California is not alone in dealing with an ag labor shortage, which is why many state legislatures across the nation have opted to introduce guest worker program legislation in an attempt to take economic destiny into their own hands. This bill will establish a first-of-its-kind worker permit program for undocumented agricultural workers, and although work authorization is a federal jurisdiction issue, a work permit program can meet all the constitutional requirements with the delegation of authority through an MOU, allowing such a program to take place in a state like California, a state that recognizes the hard work, sacrifice, and contributions of our undocumented agricultural workers. AB 20 will initiate an important conversation that must be had and proposes a creative policy approach that is practical and inclusive of employer and employee stakeholders. With me today to speak in support of this bill are Louis Brown, representative coalition of the Chamber of Commerce, California Farm Bureau, and representatives of the Western Growers, Chamber of Commerce, family winemakers, and many others. This bill has no opposition, and we ask for your aye vote.
Mr. Alejo, there were some amendments that were proposed. Are you taking those
amendments? Yes, we will
amendments?
accept those as author amendments, Mr. Chair.
Perfect. So there is a motion. Is there a second? We do have a motion and a second. I see lots of folks up there. I'll take 3 witnesses.
Mr. Chairman, members of the committee, Louis Brown on behalf of the California Association of Nurseries and Garden Centers, California Citrus Mutual, California Cotton Growers and Ginners Associations, and the California Fresh Fruit Association in support of the bill. It's hard to remember how many years we've actually been trying to work comprehensive immigration reform through Congress. We've done this attempted it on a bipartisan basis. We've walked the halls of Congress with members and friends in the union and others in industry seeking some type of resolution. Unfortunately, for any number of reasons, that resolution has not come through. And so we've come back to work with Mr. Alejo on an idea that we'd actually worked through a few years before with Mr. Manuel Perez on how can California move through? How can California try to be the leader in this area? We know from other states that we simply can't move forward with our own program. There is federal preemption. So this creative approach offers something for our industry and offers something for the state of California to be a leader in this area. We create a committee that's overseen by the governor. We propose and develop a plan, submit to the federal government for them to approve. If they approve, then California can move forward with its own agricultural worker permit program. The language that we've utilized and drafted in this bill is similar to that language that's been drafted and discussed by Senator Feinstein and others in Congress for years. We think it's a reasonable, creative approach to allow California to hopefully put some additional pressure on Congress, but if not, lead in the effort of creating some form of immigration reform for California agriculture. We ask for an aye vote.
Thank you. Next witness, please.
Good morning, Mr. Chairman, members of the committee. I'm Brian Little with the California Farm Bureau Federation. Louis said that he couldn't remember how long we've been working on this. I can tell you it's been since 1994. when I first started at American Farm here in Washington. Immigration is a really tough issue. It's been very difficult to make any real headway on this. But I think a bill like AB 20 sends a strong message from the most populous nation in the country, from the largest agricultural producing state in the United States, that this is an issue that's well past time, that we need to have some sort of resolution of it. And for that reason, I'd urge your support. Thank you.
Thank you. Next witness, please.
Good morning. Matthew Allen, Western Growers Association. We, too, are also extremely supportive of this bill and have been working over the last many years on comprehensive immigration reform. This bill sends a very strong message to Washington that California is willing to move forward in this important area. And immigration reform is very important for our industry moving forward to ensure that we have long-term labor stability. We urge your support.
Thank you. Other witnesses in support? If you could just...
Dennis Albiani on behalf of the California Grain and Feed Associations, California Seed Association, California Pear Growers. We support.
Thank you. Others in support? Just name, organization, and support, please.
Margot Parks on behalf of Family Winemakers of California in support.
Thank you.
Tricia Geringer, Agricultural Council of California in support.
Juan Peña, youth organizer with the Youth Justice Coalition in support, because myself, I'm undocumented, and so is many of my family members, and will help a lot of my family members.
Thank you.
Hello, my name is Edilberto Flores. I'm from the Youth Justice Coalition. This AB 20 will go ahead and help out a lot of families to not go ahead and get deported, and it will go ahead and stop the cycle of broken homes.
Thank you. Just state that you support.
Se Gallegos with the Youth Justice Coalition in support of AB 20.
Thank you.
Justin Oldfield with the California Cattlemen's Association in strong support.
Thank you. Any other witnesses in support? Any in opposition? Any witnesses in opposition? Seeing none, I'll bring it back to the committee for comments, questions. Mr. Gallagher.
So, being in the agriculture industry, I totally understand that we're very reliant on immigrant labor. I would say that most of those laborers are legally here in the United States, although many are undocumented, as you said. I don't know the exact percentages on that, but I understand the need there, and it would be nice to have a federal program that allowed people to come work legally, kind of like we used to have the Bracero program, which I think worked very well here, but we don't have that option anymore. I guess my concern would be, just like with Ms. Gonzalez's bill before us, this isn't a reality yet. The feds haven't acted, so there really is no program that would be available, and it could be that we're doing, much ado about nothing. There is going to be some costs here, according to the EDD and the Department of Justice. We have a lot of priorities that we need to address here in the state of California, as you know, and money is not always abundant. So, how do we ensure ourselves that we're not putting money into something that's not going to become a reality anytime soon?
Well, to answer that question, we all recognize there's a serious problem now, and we're focusing on the agriculture industry because that's where the greatest need is. That's where farms are being hurt now because of the shortage of labor, people to pick our crops, do the work that many do not want to do. If we give them a way to work lawfully and continue paying taxes, keep contributing and providing for their families, that's certainly going to be an economic benefit in the billions of dollars to California's economy. Every study that has been done on immigration reform, when workers are able to be employed lawfully through work permits or through an immigration reform, all the studies show that it's a positive net economic benefit in the billions of dollars for the country as a whole, but certainly for California, which has the largest number of undocumented workers, it certainly would be a big economic benefit for us here locally. We've done all the work that people could imagine on hopefully trying to reach a comprehensive immigration reform. I've been on the delegations to D.C. with the Western Growers, the Farm Bureaus, the Silicon Valley Leadership Group, the California Strawberry Commission. We've met with all the stakeholders, but as you know and was made very clear, this year nothing will happen, nothing will go through Congress this year in comprehensive immigration reform. So this bill is a recognition that, well, if nothing will be done at the federal level, then states like California, who do recognize the value of immigrant labor and how important they are to our agriculture industry, let us us create a pilot program that would allow a lawful way for them to be employed and continue contributing to a state like ours.
But we wouldn't even be able to move forward with a pilot program, right, unless there was federal legislation
Absolutely.
that authorized it,
That's
right?
that's what's laid out in this bill, the language of this bill.
Other comments from
Yeah,
committee?
if we, Mr. Brown would like to add on to that.
Mr. Chairman, if I so through the chair.
Did you have more, Mr. Gallagher, to ask? Okay. No, we don't have any other comments from the committee members. It's been moved and seconded. The recommendation is do pass as amended, 2 appropriations. Mr. Alejo, you may close.
I respectfully ask for your aye vote, and I'll take my last comment as my close.
Thank you. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Aye. Wagner, aye. Alejo?
Aye.
Alejo, aye. Chow? Chu? Aye. Chu, aye. Gallagher? Garcia?
Come on, Gallagher.
Okay. Garcia was aye. Garcia, aye. Holden? Mainshine? Oh, Mainshine, aye. O'Donnell? Aye. O'Donnell, aye.
That bill is out.
Thank you very much.
Thank you. And we will move to item 14, which is AB 1390. Mr. Alejo.
So my witnesses could stay up here. Good morning again, and today I'm here to present AB 1390, a bipartisan bill that will bring efficiency to the process of adjudicating water rights in groundwater basins. Before I begin, I would like to first accept the proposed author's amendments as outlined in the committee analysis, and I would also like to state that it is my promise to continue working with the committee, the governor, and the administration, and all stakeholders to find an appropriate balance between the Sustainable Groundwater Act and groundwater adjudications. When the governor signed SGMA groundwater package last year, there was an interest in streamlining the adjudication process, and AB 1390 will work in conjunction with the Sustainable Groundwater Management Act to do just that. For this reason, this bill has attracted 16 co-authors from both parties and both houses in the legislature, and the goal of AB 1390 is to clarify court procedures that apply to comprehensive groundwater adjudications to reduce the time and improve efficiency of the process. Specific provisions of this bill will encourage early settlement and avoid undue disruption of local groundwater planning. And in much of California, management of groundwater resources will be made easier by the identification and quantification of local groundwater rights, the purpose of an adjudication process. But that process is longer and less efficient than it should be. Making groundwater adjudication more efficient will relieve the burden on the courts, and at the same time it clarifies groundwater rights, bringing a double benefit to the entire process. While the bill will make the process quicker and easier, we are under no illusion that adjudications can be made short and easy. However, AB 1390 will certainly make the process more efficient while protecting due process rights for all involved. Also, I would like to make very clear that this bill is not intended to circumvent the requirements of the Groundwater Sustainability Act, but it's, as stated, supplement the Act and further its goals. And as promised, it is my commitment to work with all the stakeholders, this committee, and the administration to figure out the best approach to having the Groundwater Sustainability Act and the groundwater adjudications work together so that we can have an adequate and sustainable water supply for years to come. With that, I respectfully ask for an aye vote. And again, this bill had unanimous bipartisan support. It was 14-0 in the Assembly Water, Parks, and Wildlife Committee. And I have some witnesses to speak in support of the bill.
Thank you. First witness, please.
Hi, Dennis Albiani, representing California Grain and Feed, California Seed, California Pear Growers, and Almond Hullers and Processors Association, with as well as other agricultural organizations. We support current law. I think it's very important to point out, currently has a process for groundwater adjudication that has evolved since the state became a state, and it's guided by common law and rules of civil procedure. What the folks did is sit down with a wide group of stakeholders, water attorneys as well as the agricultural interests, and develop how can we shorten this adjudication process, which can often take between 10 and 15, 16 years. It also takes significant expense, and anything that takes that long in the court system obviously adds expense. This proposal only retains all the rights of all the stakeholders, but tries to shorten some of the time sinks. The two other witnesses will talk about some of those specifics. We want to give a short overview. And then how does it mesh with SGMA, the Sustainable Groundwater Management Act that we passed last year? That act purely deals with managing of a groundwater resource within a basin. Adjudications determine the rights of all the landowners within any basin or sub-basin. So they are different from that standpoint, but then they mesh together. Once the rights are determined, then they can be managed appropriately in any basin as with existing law. This legislation is a procedural bill that tries to narrow all those very specific and detailed issues while retaining due process. So, as we discussed, it's been written with input from a wide variety of stakeholders, met with folks from the Judicial Council to the aqua attorneys to business interests and other folks like the Water Foundation to be able to get all types of input to make sure we don't address the policy, just the procedurals of groundwater adjudication. With that, I turn it over to my fellow witnesses.
Thank you. Next witness, please.
Jack Rice with the California Farm Bureau Federation. I'd just like to highlight, I think the committee analysis did a very good job walking through how the bill would function, but I just want to highlight a few key issues. One of the first things is that this bill would apply to all the groundwater basins in California. So even though much of the discussion is around the Sustainable Groundwater Management Act, it would be available for all the other basins other than the 120 that are subject to SGMA. It's an important thing. It's strictly procedural, and in that process, we focused a lot on trying to make sure due process is adequately protected, and there's an ongoing discussion about that, and we're very cognizant of that and making sure that due process is adequately protected while also allowing it to move forward efficiently. Another issue that we're continue to work on is exactly how this will be implemented with the counties and their concerns, and we want to make sure that we resolve that. Really, the time sinks that we're focused on are whether it's really appropriate to have a comprehensive adjudication. There's a mechanism in there through the hearing to determine that. The judicial disqualification, that's been an issue, a hang-up that has caused a lot of time and expense to be added. The notice and service issues are because so many parties are part of this process. The case management, one of the areas where the individual landowners are protected is through case management and the fact that there is a ability to treat these as class actions. And so with that, I think I'll just leave it for more technical questions.
Thank you. Next witness, please.
Good morning. Lauren Hajic on behalf of the California Fresh Fruit Association, California Citrus Mutual, Western Agricultural Processors Association, and various other agricultural commissions and associations throughout the state. We're in strong support of this bill because of the efficiency it grants in allowing more parties to be actively engaged in the adjudication process. As stated, the current process is very onerous and allows for various delays that extend these adjudications between 15, 20 years. Some are still ongoing. Because of this, smaller landowners don't often have the means to actively engage in this process. And while groundwater adjudications are always going to be extensive and technical, AB 1390 will allow for a more streamlined process so that smaller landowners can engage in the adjudication action. One of the ways that this can happen is through the preliminary hearing that Jack Rice touched on. The court holds a preliminary hearing to ensure that a comprehensive adjudication is appropriate, so that if it is not appropriate, the entire basin doesn't get dragged into this litigation. Second, the court can also form classes and phase the adjudication action so that issues can be solved up front and that smaller landowners can be grouped in a class to allow them to have an attorney on their behalf without the extensive expense of engaging with their own attorney. The court can also stay the proceedings to allow the parties to engage in the groundwater adjudication process so that the parties can go through the Sustainable Groundwater Management Act and then come back to the court with a possible stipulated judgment based on the Groundwater Act passed last year. The court also will require historical pumping data up front in the adjudication action. It's said that often parties hold back their pumping data, which delays the proceedings. This way, all parties would have their cards out on the table, which would facilitate settlement and allow the court to be able to determine those groundwater rights in a more efficient manner.
Thank you.
Thank you.
Thank you. Other witnesses in support, please state your name, organization, and your support.
Gail Dillahant with Western Growers Association in support.
Thank you.
Justin Oldfield with the California Cattlemen's Association, strong support.
Tricia Garinger, Agricultural Council of California in support.
Chair and members, Dan Pone for the Judicial Council. We don't have an official position yet, but we've been working very cooperatively with the sponsors on a series of technical amendments, some of which have already been taken. We'll probably have some additional suggestions in drafting, and we look forward to continuing that productive conversation. Thank you.
Members of the committee, Kathy Mannion, RCRC representing 34 rural counties. I'm a tweener here today to express our concerns with certain provisions of the bill that we believe are overbroad and also some procedural issues that are problematic for counties. However, we have had a very good meeting with the sponsors of the bill. We anticipate having another meeting in the very near future, and we're very hopeful we'll be able to resolve all of our issues. Thank you.
Thank you. Any other witnesses in support? Seeing none. Anyone in opposition? Could you make room for them at the table, please? Come up to you can come up to the table.
Debbie Orrs with the Community Water Center, and we are opposed unless amended.
Thank you.
Kyle Jones with Sierra Club California. We appreciate the amendments taken and think that it's a great step to take in this bill. We are still concerned with the settlement provisions contained in the bill. As it's written now, with 50% of the named parties and 75% of the water producers agreeing, the courts have to accept a stipulated judgment, and it places the burden on the opposing party to defeat this stipulated judgment. We're concerned about the number of parties being very low, and then also that the 75% of the produced water that comes from the past 10 years of pumping. Considering the drought we're in, that favors those who have been able to dig deeper wells, leaving those who have dried up wells out of the bargaining table. We're very concerned about that process and would hope to see maybe some amendments going forward on that. Thank you.
Thank you.
Kelly Ditto on behalf of California League Conservation Voters, also opposed unless amended. Thank you.
Thank you. Any other witnesses in opposition? All right, seeing none, we'll bring it back to the committee. And Mr. Alejo, thank you for taking the amendments that we worked on with you. I appreciate that. And we do recognize that the Sustainable Groundwater Management Act and the adjudication process need to be harmonized, and the administration, I think, needs some room to be able to do that. That was part of the reason for the amendments, and ensure that we can all sort of figure all of this out. But other than that, being able to address the adjudication process, I think, is a great step, and I appreciate that you brought this. Any other comments, questions from committee members? Mr. Gallagher.
As you know, I'm a big fan of streamlined processes, groundwater adjudication, CEQA, streamlining for water storage projects. So I'm supportive of your bill, and I'd like to also, with your acceptance, I'd like to be added as a co-author. But one question I did have is, I know when we did pass the SGMA, there was at least somewhat of a tacit admission that basins that had been adjudicated didn't need to be part of SGMA. And I know in your original legislation we had allowed, hey, if this is adjudicated before 2020, then it wouldn't fall under SGMA. We've taken that out. But I wonder, for the purposes of discussion, we sort of tacitly admitted that adjudicated basins have sort of already done this, have sort of already done the local groundwater planning. And I think going forward is at least worth a discussion that if a groundwater basin gets adjudicated and all those rights have been determined, do we really need to have a GSP or GSA for that region? Maybe you can address that.
I'll let our expert answer that.
Thank you, Mr. Gallagher. No, it's a very good point, and I think that originally the bill had included that idea that the best way to treat adjudicated basins were like they were treated before. But there were concerns with the administration and others about if that was the right way to integrate streamlined adjudication with SGMA. And the fact of the matter is there is a range of concerns about how that could actually play out in the real world. And the language that was originally proposed didn't hit the right mark there. So while we are continuing to have a discussion about how to integrate those, that language was not workable for important folks. And so we need we're going to continue the discussion, but we have to move away from that language.
Other comments, questions from committee members? All right, Mr. Alejo, you may close.
Thank you, Mr. Chairman. Again, thank you to your staff for your work on this bill. But I think we all recognize and the governor recognized last year, this was something that we were going to need to work on this year in terms of expedited water adjudication. But this is a bill that has been based on consensus building. A lot of stakeholders, a lot of people who disagreed came together on a pretty comprehensive bill that deals with a wide range of issues. And even in our early meetings with the governor, there seemed to be a recognition that we all agreed on probably most of this bill. It was only a very small percentage that we recognized we'd have to keep refining as the bill moved forward, and that's where we are at today. So I appreciate the support, but we're about getting work done and resolving problems. You all heard that there was cases and that had been adjudicated in other parts of the state where there were dozens of parties, dozens of lawyers litigated in the millions of dollars, and 15 years later, they're still being adjudicated and not coming up with much solution. I think we've learned from those lessons, and that's why we incorporated a lot of the lessons learned from those other cases into this bill, and I respectfully ask for your aye vote once again on this bill.
Thank you, and I'm still looking for a motion. The recommended motion is due pass as amended to appropriations.
Move the bill.
Would that be adding me as a co-author as well?
That's up to the author to make that amendment at the next.
We will do it at the next stop.
Okay.
At the next stop. So we do have a motion and a second. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner?
Aye.
Wagner, aye. Alejo?
Aye.
Alejo, aye. Chow? Aye. Chow, aye. Chu?
Aye.
Chu, aye. Gallagher?
Aye.
Gallagher, aye. Garcia? Holden? Mainshine? Mainshine, aye. O'Donnell?
That bill is out.
Thank you very much.
That brings us to item 10, AB 900, Mr. Levine. Glad to see we've got some authors here. And having finished that bill, that takes us halfway through our agenda today.
Thank you, Mr. Chair and members. I remember dropping into this room at 8 a.m. To make sure that we could help move this committee around and along today.
And you are our priority right now.
Thank you, sir. AB 900 seeks to better align state and federal law in order to protect vulnerable, unaccompanied immigrant minors up to 21 years old. Under existing law, probate courts can establish guardianship for these youth only up to age 18. AB 900 will allow courts to establish guardianships for those youth up to 21 years of age, and thereby provide immigration relief in two ways. First, this will provide youth a better opportunity to adjust to life in California by allowing them to have an adult guardian. Second, this bill will help increase access for them to remain in the United States legally. Under federal immigration law, immigrant children under the age of 21 may obtain special immigrant juvenile status known as SIJS. However, a child may only apply for SIJS if the child receives a state court order with factual determinations made by a judge. This bill will give California courts the authority to make those determinations up to age 21 so as to match existing federal law. AB 900 will remove an unintended roadblock for undocumented youth to remain in this country legally and also provide stability in their lives through the support of the state court and a legal guardian. Here to speak in support of the bill is Rachel Prandini with the Immigrant Legal Resource Center.
Move the bill.
So we do have a motion. Is there a second? There's a motion and a second. Your witness, please. Please.
My name is Rachel Prandini.
Could you push the button on the table there? There you go.
My name is Rachel Prandini, attorney at the Immigrant Legal Resource Center, which supports AB 900. The Immigrant Legal Resource Center is a nonprofit organization that provides training and resources in the area of immigration law and immigrant rights for practitioners and community organizations throughout the country. We have extensive experience working at the cross-section of juvenile state court issues and immigration law and published the only national manual on special immigrant juvenile status. I want to briefly share the story of a young woman that powerfully illustrates the need for AB 900. A young woman came to a nonprofit legal services organization in December of 2014 after fleeing horrific abuse in Honduras at the hands of her mother and stepfather, and still bearing deep scars on her back from her mother's beatings. She was residing with her aunt in the Los Angeles area and came to their office only 3 weeks shy of her 18th birthday. Because of her age, they were unable to seek special immigrant juvenile status on her behalf, an important form of federal immigration relief for children who have been abandoned, abused, or neglected by a parent, despite her clear eligibility under federal immigration law. This is because under current California law, probate courts do not have the ability to take jurisdiction over youth who are 18 and over, to appoint a guardian on their behalf, and make factual findings that will allow the youth to apply for special immigrant juvenile status. As a result, this young woman remains in deportation proceedings, living with a constant fear of deportation back to a country where she knows she will experience more abuse, and in the interim is living here without the benefit of having an adult guardian. This bill will give probate courts jurisdiction to appoint guardians for youth ages 18 to 20 in connection with a petition for the factual findings for special immigrant juvenile status. In doing so, it will align California law with federal law, which allows youth to apply for this relief up until the age of 21. Without this change, youth in California between the ages of 18 to 20 will continue to be unable to apply for this relief despite their eligibility under federal immigration law. We believe that this bill will provide crucial protection to some of the most vulnerable young people in our state, many of whom have fled alone from dangerous conditions in their home countries. AB 900 will protect immigrant youth in two important ways. First, it will extend jurisdiction so that older teens without parental protection in the United States can have a fair shot at assimilating to life here. And second, it will increase access to special immigrant juvenile status. The California legislature has already taken important steps to ensure that children have access to this form of relief, but significant barriers continue to exist. This bill will remove a significant barrier and ultimately lead to safety and stability for immigrant youth in California, a benefit to both those youth who receive protection and to our society as a whole.
Thank you. I'm going to need you to wrap up, please.
Thank you, and we urge your support.
Thank you. Any other witnesses in support?
Gina De Silva with the California Immigrant Policy Center, strong support.
Thank you. Any other witnesses in support? Any witnesses in opposition? Seeing none, I'll bring it back to the committee. Questions, comments? All right. We do have a motion and a second. The recommendations do pass to appropriations. Mr. Levine, you may close.
I respectfully ask for an aye vote, Mr. Chair.
Thank you. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Alejo? Chow? Chow, aye. Chu? Chu, aye. Gallagher? Garcia? Aye. Garcia, aye. Holden? Mainshine? O'Donnell? O'Donnell, aye.
You need one more vote, so we will hold that bill on call.
Thank you very much.
Thank you. Mr. Nazarian, this brings us to item 9, AB 829.